Good morning, everyone, and welcome to this webinar on bail. I'm literally going to just wait maybe 1 minute more, just to let people into the meeting, and then we'll start. So if you could just bear with us for one meeting, because there are a number of people that are still being admitted into the meeting. Thank you very much. All right. Good morning, everyone. We're ready to start. I see there are a number of participants who have joined us. Welcome, everyone. Firstly, let me introduce myself. My name is Bronwyn Pithy. I am an advocate at an NGO called the Women's Legal Centre, which focuses on strategic litigation, specifically around women's rights, and I'm responsible for the right to be free from violence in that program. My background is that I was with the Department of Justice and the National Prosecuting Authority in particular for 15 years. So I'm very excited now to be able to facilitate or moderate a session that looking at improving access to justice for women who, particularly in domestic violence relations, in relation to bail of perpetrators who have been arrested in connection with domestic violence issues in particular. But I'm not going to go into any detail with that. I just wanted to first acknowledge that this is a webinar that is facilitated and presented by the Department of Justice in relation to the Pillar 3 activities from the National Strategic Plan on Gender-Based Violence and Femicide. It is a part of a webinar series to update and inform people of all the amendments to the 3 GBV acts. We used to call them the bills. Now we've got to call them the acts, as they've all been passed, which has really been a monumental task and has sat predominantly with Pillar 3 from the NSP, and really to acknowledge the work, particularly of Advocate Kambula Praise Kambula, sorry, wrong way around. Sorry, Praise Kambula, who is the coordinator of Pillar 3. Most of you, I don't need to introduce Praise. She is here with us today to answer any questions if we do have near the end of the session. But obviously, just to really commend that leadership and the drive behind getting all of these acts in place. As most of you know, Advocate Kambula has been with the department and was initially with the National Prosecuting Authority and then with the department for the last few years, and is the Chief Director, the head of the Promotion of Rights of Vulnerable Groups unit, and has really sat with the responsibility of making sure that these pieces of legislation go through. The presenter today is Advocate Karina Kutsia, who also has a very long history of working with the Department of Justice and with the National Prosecuting Authority, and really has focused specifically on gender-based violence already since the 1990s, and then specifically around children, concerns around children, but really broadly, and works for the Sexual Offences and Community Affairs Unit, which is a specialized unit within the National Prosecuting Authority, specifically looking at vulnerable groups, victims, survivors of gender-based violence. So we really have the specialists in the room. They're going to be looking specifically at the bail amendments in relation to the Criminal and Related Matters Amendment Act of 2021, number 12 of 2021. So what I'm going to do is hand over to Karina now, and she will do the presentation. And if you could please use the chat box or the Q&A box for any questions, and then we'll take those questions and we will answer them to the best of our ability between us. Also, in addition to that, could you, in the chat box, leave your email address? So Luando at a later stage can email a copy of the presentation to you so that you have that. And then also just to mention that probably by the end of July into August, all of these webinars will be uploaded so people can have access to them as training material, etc. Okay, so I've taken up enough time. I'm going to hand over to Karina. Her presentation is already on the screen. And Karina, thank you very much for taking us through this, and we look forward to your presentation. Thank you.
Thank you very much, Bronwyn, for the introduction. And yes, I do want to also agree with you in terms of the hard work and fantastic work that the NATTEC, under the chairmanship of Praise Kambula, is performing, really. We're doing fantastic work. And yes, these are the legislation, the three pieces of legislation, one of the three pieces of legislation that we had been waiting for a considerable period of time. Anyone that was involved in the presidential summit of 2018 would know what I'm talking about. And trust me, as Bronwyn had pointed out, a long and hard work had gotten us where we are now, where we can actually present on the amendments that is going to become effective on the 31st of July, 2022. But without further ado, Uyan, just as I thought, it worked so well. Maybe. I can't seem to move it now. I'm going to stop sharing and then start again just to ensure, because I don't know what went wrong now. The background to this, as I've pointed out, these are one of the pieces of legislation that we had been waiting for a considerable period of time, well, at least 4 years, and I'm very happy that it is eventually coming to fruit, that it's eventually coming effective. So yes, the amendments for the Act 12 of 2021 did amend the Chapter 9 of the Criminal Procedure Act that deals with procedures and requirements for the release on bail, as well as the requirements for the cancellation of bail in terms of Section 68 and conditions for the release of bail in terms of Section 59, what we would call normally police bail, Section 59 capital A, bail that can be set by a prosecutor, and then of course in terms of Section 60, bail set by a court. Bail applications, in terms of State versus Hewu, it was ruled or held that for a Schedule 5 and 6 offence, accused cannot be summoned to court. Accused can only be arrested, because only a court can decide whether accused can be released from custody. A prosecutor or a police official cannot make that ruling. Only a court can, in terms of Schedule 5 or 6 offences. But the bail legislation also require that for a Schedule 5 offence, before an accused person can be released on bail, the accused must adduce evidence. This evidence can be oral, viva voce, or by means of statements, must adduce evidence to prove that it's in the interest of justice to permit his or her release on bail. Now, the burden of proof, that means that the burden of proof is actually on the accused person to prove that it is in the interest of justice to release him on bail. But that burden of proof is not the same as the burden of proof for the state. The state's burden of proof is beyond a reasonable doubt, and for the accused, it's on the balance of probabilities. So your burden of proof in a bail hearing would be on a balance of probabilities. For a Schedule 6 offence, the accused must, again, after adducing evidence, prove that not only is it in the interest of justice, but that exceptional circumstances exist that makes it in the interest of justice for the accused to be released on bail. So just to setting out what Schedule 5 or Schedule 6 offences would be: murder, attempted murder with the infliction of grievous bodily harm, rape, compelled rape of an adult, tip offences, trafficking in persons offences and contraventions of Section 5, 6, 7, 8. 10 if it is relating to offences of 5, 6, 7, 8, and 23, drugs. Offence committed by a member of SAPS, a South African Police Service, sexual assault, compelled sexual assault of compelled self-sexual assault of a child. And that is where the amendment was, where the amendment is. The amendment made it under 18 years. Previously, it was for a child under the age of 16 years. The amendment now makes it under 18 years or previously convicted for a sexual offence. I have surrounded the amendments that had been made by Act 12 of 2021. Murder, when it was planned or premeditated, the victim was a law enforcement officer. The victim was likely to provide material evidence of an offence. The death was caused by the accused committing or attempting to commit rape, compelled rape, and robbery with aggravating circumstances. Schedule 6 offence, rape, compelled rape, when the victim was raped more than once, more than one person raped the victim, the accused is charged with the commission of more than one rape or compelled rape. The accused was HIV positive during the commission of the offence and was aware of his status. The victim was under 18 years old. Again, this is where the amendment comes in. Previously, it was under 16 years old. From the 31st of July, it's going to be under 18 years old. The victim was a person with a mental disability or another disability or any other disability that renders the victim vulnerable, involving the infliction of grievous bodily harm, trafficking in persons in contravention of Section 4, or any offences related to an offence in terms of Section 4 of the Trafficking Act, robbery involving a firearm, infliction of grievous bodily harm, or the taking of a motor vehicle, a Schedule 5 offence if the accused was previously convicted for a Schedule 5 or 6 offence. The accused was on bail for a Schedule 5 or 6 offence. Schedule 7 offences. Schedule 7 offences are more serious than that for which police may fix bail under Section 59, but less serious than Schedule 5 and 6 offences. For example, robbery, housebreaking, theft, fraud, where the amount involved does not exceed 20,000 rand, possession of drugs, culpable homicide, arson, malicious injury to property, or assault involving the infliction of a dangerous wound, infliction of grievous harm, or threatening a person with grievous bodily harm, a firearm, or dangerous weapon. Section 59, sub 1, sub A, the accused who is in custody may not be released on bail by a police officer before first appearance in court for an offence referred to in Part 1, 2, and 3 of Schedule 2 of the Criminal Law Amendment Act 105 of 1996. Sorry, it's 1997. I'll fix that. Against a person in a domestic against a person in a domestic relationship as defined by Section 1 of the Domestic Violence Act 116 of 1998, or referred to in Sub AA, Section 17(1)A of the Domestic Violence Act 116 of 1998, B, Section 18(1) Sub 1 Sub A of the Protection from Harassment Act 17 of 2011, contravention of a court order to protect the person against whom the offense was committed from the accused. So it's actually important to remember that what section to remember what the requirements of Section 59 Sub 1 Sub Roman 2 and Roman 3 is, because we are going to find the reference to Section 59 Sub 1 Sub Roman 2 Sub Roman 3 throughout the amendments of the bail conditions and bail requirements. What Section 17(1) Sub A of the Domestic Violence Act prescribed is any person who contravenes any prohibition, condition, obligation, or order imposed by a final protection order from the court in terms of Section 7 of the Domestic Violence Act is guilty of an offence. And Section 18(1)A of the Protection from Harassment Act requires that any person who contravenes any prohibition, condition, obligation, or order imposed by a protection order from the court by Section 10 of the Protection from Harassment Act 17 of 2011 is guilty of an offence. Part 1, Schedule 2, if you can remember, the police is not allowed to set bail prior to the first appearance in court. In other words, that is again where State versus Haywood comes in. An accused cannot be summoned, because that is the police releasing the accused from custody against what the requirements of this legislation is. In other words, an accused committing a section Schedule 5 or 6 offence must be arrested, and if it was an offence in terms of Part 1, 2, or 3, the police can not set bail before first appearance in court. We all know that once the accused appear in court, the only authority that can release the accused from custody is the court, and only on application. In other words, the state prosecutor cannot make that decision to release accused from court after the first appearance. But under certain circumstances, the prosecutor can, and we will get there. But just to inform you in terms of what a Part 1 offence would be for which a prosecutor and a police official cannot set bail: murder, attempted murder when it was planned or premeditated, when the victim was a law enforcement officer performing his functions as an officer of the law, the victim was likely to provide material evidence of an offence, or the victim was a person under 18 years old. Again, previously it was under 16 years old. It had been amended to read under 18. The death was caused by the accused committing or attempting to commit rape or compelled rape, robbery with aggravating circumstances, committed by a group acting with a common purpose, or was killed to remove her or his body parts, or as a result of witchcraft, or the death was caused by physical or sexual abuse as defined by the Domestic Violence Act 1998. Just go see what the definition for physical or sexual violence, sexual abuse is very wide. And if you think that it would be would fall within the abuse would fall within the definition of the Domestic Violence Act, it would probably, as I say, that if it was a physical and sexual abuse is defined widely within the Domestic Violence Act. Rape or compelled rape, when the victim was raped by more than one person, including a co-perpetrator, accomplice, or another victim to compel to rape her or him. Was raped by more than one person acting with a common purpose. was under 18 years old. Again, that is the amendment. Previously it was 16, now it's under 18 years old. Was an older person as defined in the Older Persons Act. Was a person with a disability that renders her or him vulnerable. Previously it was defined as a person with a physical disability that renders her or him vulnerable, but now the amendment refers to any disability as long as that disability renders the victim vulnerable. Subjected to the infliction of grievous bodily harm was a person with a mental disability as defined in the Sexual Offences and Related Matters Amendment Act 32 of 2007. It's a specific definition of a person with a mental disability in Section 1 of the SORMA Act and differs from the definition of a person with a mental disability as it would be defined in the Mental Health Act. So just take note of that. It's a specific difference. It's not every person with a mental disability. It's just as a mental disability as defined by the SORMA Act. Was in a domestic relationship with the accused. In other words, should the accused be convicted for a rape on a person with whom he was in a domestic relationship, the sentence would be life. Now, why that is also important in terms of bail, the sentence that the accused is likely to receive upon conviction is definitely a factor that a court would consider in terms of deciding whether it's in the interests of justice to release the accused on bail or not. The higher the sentence that would be imposed on the accused on conviction, the less likely the accused would be released on bail. Pending the finalization of the case. So that is therefore a fantastic amendment that was added to the Criminal Law Amendment Act to include the domestic relationship, because that again will make it easier for the state to oppose the release of the accused on bail. Rape and compelled rape, when the accused is charged with the commission of more than one rape or compelled rape, was HIV positive during the commission of the offence and was aware of his, her, or their status, acted in the furtherance of a common purpose, conspiracy, irrespective of whether anyone else had been charged, was previously convicted for rape or compelled rape, was convicted for 2 or more offences of rape or compelled rape, irrespective whether the conviction was in terms of the common law or the SORMA Act 2007, irrespective of the date on which the offences were committed, or whether the accused has been sentenced for the offences so convicted, whether the conviction was for the rape or compelled rape on the same victim or different victims, whether the offences convicted was committed on the same day or on separate occasions. Again, for the prosecution, this amendment comes in extremely helpful and handy, because previously what the Minimum Sentencing Act or what the Criminal Law Amendment Act had read in terms of this particular provision inserted in Part 1, Schedule 2, was convicted for 2 or more offences of rape or compelled rape and not yet sentenced, which the legislature on face value, it seemed like the legislature meant it to be these accused that had been convicted for serial rapes. Because very often the rapes might have been committed over a period of years, but the conviction was at the same time. And for somehow, eventually the courts had started interpreting this as separate, as not relating to the same offense. In other words, a serial of offenses. But only if and did not consider a serial rape rapists to fall within the provisions of Part 1, Schedule 2. And that is why this amendment clearly sets it up, that what the legislature intends with this provision is to provide for a life imprisonment for a person convicted of serial rapes, of a serial rape. Even if he was just convicted on one victim in a serial of rapes. If he was convicted for more than one rape, even if that was on one victim, or if that was on separate victim, as in a serial rape. Again, another amendment that had been inserted into the Criminal Law Amendment Act 105 of 97 was the rape or compelled rape, not referred to in Part 1, sexual exploitation of a child or a person with a mental disability, or using a child for child pornography, or a person with a mental disability for pornographic purposes. These offences were previously part of Part 3 of Schedule 2, which requires the minimum sentence to be 10 years. The minimum sentence is now 15 years for rape and compelled rape that does not form part of Part 1, which is also extremely needed, as in many, many cases where a sentencing court gave judgment in terms of sentencing, that the courts mentioned that the difference in sentencing for a rape in terms of Part 1 and a rape in terms of Part 3 is vast, because there's a vast difference between 10 years in life imprisonment. But at least now we've got 15 years, second offense, 20 years, and third offense, of course, 30 years. Assault to do grievous bodily harm on a child under 16 years old, or if the child is 16 or 17 years old and the accused is more than 4 years older, then the minimum sentence would be 10 years, or on a victim who was in a domestic relationship with the accused. So the legislature makes it very, very certain that an offence, assault to do grievous bodily harm on a person with whom you're in a domestic relationship, is a very serious offence for which a minimum sentence of 10 years had been prescribed. Section 59, capital A, sub 1, authorizes a prosecutor that can, before the first appearance in court, can release an accused person for a Schedule 7 offence on bail after consultation with the investigating officer, provided that the person is not accused of the contravention of an offence contemplated in Section 59, sub 1, sub A, sub Roman 2, or sub Roman 3. Now, if you remember, I have indicated that throughout this new amendments of the bail legislation, we are constantly going to be referred back to Section 59, sub 1, A, 2, Roman 2 and 3. And Roman 2, of course, refers us to a domestic violence protection order. Roman 3, of course, refers us to Roman 2 refers us to any offence that was committed against a person in a domestic relationship with the victim, with the accused, and 3, of course, refers to a protection order in terms of the Domestic Violence Act, the Protection from Harassment Act, and, of course, any protection order in terms of any law. Section 60, this provides for the conditions under which an accused can be released on bail, and the 60 sub 2 provides that in bail proceedings, the court shall, where the prosecutor does not oppose bail for a Section 5 or 6 offence, or an offence in contravention of Section 59, sub 1, sub A, sub-Roman 2 or sub-Roman 3, require the prosecutor to place on record the reasons for not opposing bail. In other words, if the offence was committed against a person in a domestic relationship with the accused, if the offence was the contravention of a protection order in terms of the Domestic Violence Act, or the Protection from Harassment Act, or any other law, then the prosecutor, in not opposing the bail, must provide reasons for not doing so. And that reasons must be recorded on the record, court record. Section 60 sub 2A had been inserted. The court must, before reaching a decision on bail, not only consider the pre-trial services report on the desirability of the release of the accused on bail, but also view the view of the person against whom the offence was committed regarding her or his safety. And that is extremely important. In other words, you will see, as if a legislation refers to must, it is an obligation, but the court has this obligation, and the court can be taken on review or on appeal should the court neglect its obligation that this act places on the court. So the court has to take that, and if the court gives judgment against the state, then the court must mention that the court had taken the views of the person against whom the offence was committed into account before coming to the ruling that the court had done. Section 60, sub 4, the interest of justice does not permit the release of the accused on bail where there is a likelihood that the release of the accused would endanger the safety of the public, any person against whom the offence in question was allegedly committed will commit an offence if released from custody. So again, if the offence was committed against a person with whom the accused was in a domestic relationship, the interest of justice certainly has to be considered before the court can decide that the interest of justice would be the release would be in the interest of justice. Section 60 sub 5, in considering the interest of justice, the court may take the following factors into account. In other words, this is not an obligation. As the legislature indicate, may the following factors into account: the degree of violence towards others implicit in the charge. If the offence that the accused is being charged for is an offence that has an element of violence, then these factors will have to be considered. In other words, the degree of violence towards others implicit in the charge, any threat of violence the accused may have made to the person against whom the offence was committed or any other person, any resentment the accused may harbour against the person against whom the offence was committed or any other person. We all know that in domestic violence cases or in partner violence, very often once the partner, the real critical phase really is after the abused partner had approached the police to lay criminal charges or to obtain a domestic violence protection order. That is really the most critical period in that person's life. And that is exactly where most of the resentment would occur, and where the assault or the abuse would, the accused will definitely increase the form of abuse after, if he does harbor this resentment, which is my experience that they mostly do. So it is fantastic that is inserted as a definite consideration, a factor that the court must consider. that the court has to consider in terms of what the legislature expects. Any disposition to violence from the past conduct of the accused, as evident from past conduct, any disposition of the accused to commit offences. The Act actually says offences in terms of Schedule 1, but Schedule 1 really contains all offences that does not that's not cited in other schedules. Offences against a person in a domestic relationship with the accused, contravening a court order in terms of the Domestic Violence Act or the Protection from Harassment Act, contravening any order made to protect the victim of the current offence against the accused. Now, these insertions into the Section 60 sub 5 are also very relevant factors to consider, especially when it's a domestic violence situation, or especially when it's an interpartner violence. Section 60 sub 5 F, prevalence of the particular offence. Section 65 G, any evidence that the accused, while released on bail or placed on correctional supervision, day parole, parole or medical parole, committed an offence. Offences against a person in a domestic relationship with the accused, contravening a court order in terms of the Domestic Violence Act or Protection from Harassment Act, contravening any order made to protect the victim of the current offence against the accused. Those are all new insertions into the Section 60 sub 5. As Section 60.10, in all bail applications, the court must weigh the personal interest of the accused against the interests of justice, and it was inserted with the new amendments, provided the interest of justice include consideration for the safety of the person against whom the offence was committed. And that is an important consideration, because in a domestic violence, especially in a domestic violence case that relates to physical violence and infliction of grievous bodily harm, the safety of the victim would become so important that the release on bail of the accused becomes almost impossible. Section 60.11, the accused must adduce evidence which satisfies the court that the interests of justice permit his or her release on bail if it was a Schedule 5 or 6 offence or an offence contemplated in Sections 59 sub 1 sub A, sub Roman 2 or sub Roman 3. So again, sub Roman 2, an offence against a person in a domestic relationship with the victim or with the offence, the person against whom the offence was committed, or contravention of a protection order in terms of the Domestic Violence Act, or the Protection from Harassment Act, or any court or any law. So in other words, what is, by inserting this provision, an offence contemplated in Section 59 sub 1A, Roman 2 and 3 into Section sub 11, Section 60 sub 11 indicate that the legislature is now making the same requirements before an accused can be released on bail for these offences as for the offences that falls within the Schedule 5 and 6, which are extremely serious offences, as we've seen as related what Schedule 5 or 6 offences are. In other words, before the accused can be released on bail, the accused has to convince the court that the interest of justice permits his or her release on bail on the balance of probabilities. So it is basically, it becomes a Schedule 5 offence because the accused has to prove the interest of justice. We've seen with Schedule 5 offences, the accused must prove that it is in the interest of justice. And once the accuser proved that it's in the interest of justice, then of course the state has to prove that it is not in the interest of justice. And for Schedule 6, the accused must prove that exceptional circumstances exist that makes it in the interest of justice. And once the accused has proved that, the state must again prove that the factors that the accused had listed are not exceptional circumstances as envisaged by the legislature, and that it's not in the interest of justice to release the accused on bail. And I can just also note that the state's case, the strength of the state's case, is certainly an aspect or a factor that the court will consider in deciding whether it's in the interest of justice to permit the release of the accused on bail. Section 60 sub 11 capital B, during bail application, the accused must inform the court of previous convictions, whether charges are pending against him or her, or whether an order in terms of the Domestic Violence Act 1998 or Protection from Harassment Act 2011 was issued against the accused to protect the person against whom the offence was committed against the accused. The accused was a sentenced offender on parole for commission of an offence. And this is also an obligation that the accused must inform the court of these factors, and if the accused does not do so, the bail can be cancelled. Okay, what happens if the bail is in favour? Bail application is in favour of the accused. The new insertion into the Bail Act or into the Criminal Law Amendment Act, into the Criminal Procedure Act 51 of 1997 regarding the issuing of bail is also extremely needed and something that we can be very, very proud of. The court must issue, when the court decides in favor of the accused and release the accused on bail, the court must issue a protection order against the accused if the accused is in a domestic relationship with the person against whom the offence was committed. That is extremely important. Furthermore, Section 60, sub 12, sub A, the court may make the release of the accused subject to certain conditions in the interest of justice, provided the interests of justice include consideration of the safety of the person against whom the offence was committed. 60, sub 12, sub B, if the court is satisfied that the interests of justice permit the release of the accused on bail for an offence committed against the person whom he or she is in a domestic relationship and a protection order was not issued against the accused, the court must, after holding an inquiry, issue a protection order in terms of Section 6 of the Domestic Violence Act 1998 against the accused, whereafter the provisions of the Domestic Violence Act shall apply. What happens if the accused fails to observe the bail conditions? Of course, then on application by the state, the court can cancel the bail. And Section 68, sub 1, requires a court before which a charge is pending for which the accused is on bail must issue a warrant for the accused arrest, including cancelling the bail, and order the accused incarceration until the finalization of the case if the court receives information under oath that the accused is about to abscond, evade justice, interfere or threaten to interfere with witnesses, defeated or attempted to defeat the ends of justice, or a new insertion, C, capital A, accused contravene a prohibition, condition, obligation, or order issued in terms of the Domestic Violence Act, Protection from Harassment Act, or any other law. Accused poses a threat to the public. to the public. Remember, before I move on, if you look at C capital A, remember, before the court can release the accused on bail, if the accused had committed an offence against the person with whom he is in a domestic relationship, the court must issue a protection order. Now, if the accused then contravenes that protection order, that prohibition or condition, obligation or order, any prohibition, condition or obligation as part of that order, then immediately he can be arrested and brought before court for the cancellation of his bail. The accused poses a threat to the public. The person against whom the accused the person against whom the offence was committed, or any other particular person. The accused failed or incorrectly disclosed previous convictions. The accused failed to disclose a prohibition, condition, obligation, or order issued in terms of the Domestic Violence Act 98, Protection from Harassment Act 2011, or any other law. Further evidence became available, including that the accused provided false information. It is in the interest of justice to do so. So I also want to say, if the accused contravenes a prohibition, condition, or obligation set by a protection order, not only is that a factor from which the court can cancel his or her bail, but it's a new offence. Of course, he has committed an offence, and that offence can be added to the eventual charges against the accused. Section 60, sub 2, any magistrate may issue a warrant of arrest and order the incarceration of the accused until the finalization of the case upon application of any peace officer or a written statement under oath by such officer that there is reason to believe that the accused is about to abscond or evade justice, accused interfered or threatened to interfere with the witnesses, accused defeated or attempted to defeat the ends of justice, the accused poses a threat to the public, the person against whom the offence was committed, or any other particular person. The accused failed or incorrectly disclosed previous convictions. Further evidence became available, including that accused provided false information. The accused contravened a prohibition, condition, obligation, or order issued in terms of the Domestic Violence Act, Protection from Harassment Act, or any other law. The accused failed to disclose that he or she was under parole or correctional supervision. Parole would include day parole, medical parole, or any other type of parole. The accused failed to disclose a prohibition, condition, obligation, or order issued in terms of the Domestic Violence Act, Protection from Harassment Act, or any other law, or it is in the interest of justice to do so. So we can see the courts have got wide powers to actually incarcerate and keep a person incarcerated for the duration until the finalization of the case, if the offence was committed, if the accused committed an offence against a person with whom he or she was in a domestic relationship. Yes, and that is conclude the amendments to the bail regulations in terms of the Criminal Procedure Act. Thank you.
Karina, thank you very, very much for that extraordinary presentation. As most of you who are familiar and maybe not that familiar with these amendments, as you can see, they are of a highly technical nature for those of those of you who don't kind of work with this area of law every day. And I can see from the chat and also from the Q&A that everyone has put their emails in. If you haven't put your emails in, please do so, and the presentation will be sent. I think maybe, almost in summary, one has to it's difficult to summarize, obviously, all of these amendments, but I really think that the kind of almost the theme that goes right through the amendments is that there is a real recognition and understanding that the courts must take into consideration the voices and protection and safety of victims, and I think that in and of itself, those amendments really do reflect that, and it's really going to be a matter of implementation and ensuring that all of that information is placed before the courts. So that will have to be a combination of investigating officers and prosecutors making sure that all the relevant information is placed before the court. I saw one question effectively in the chat box. I think that I can't scroll up to it again because I might not find it, but there was a question that I did see, and I may have missed some others, and I might need a little bit of help from Luando if necessary. But the one question I saw was, do these amendments apply to cases that are currently in court? And maybe just to clarify, at the moment, the I can never say this word. Basically, when these acts come into operation, that is when obviously these provisions will apply. So at the moment, there we go. There's the question: do you have any amendments that affect cases in court? The issue really is that we have to wait until these acts are operationalized, which at the moment should be at the end of July. So they probably will not have, and Karina, actually, I might even ask you to comment on that. I don't think that they would have retrospective application to cases that are potentially before court already. I may be wrong. I maybe can hand over to you. If you could answer that question, would be useful. Is it only going to apply once?
Yeah, you see that these are procedural regulations, legislation. So it would apply from, it would, any bail application that happens after, that would apply to any bail application that happens after the 31st of July, if it becomes effective on the 31st of July. In other words, it wouldn't only apply to the bail application of offences committed after the 31st. That's not how procedural legislation works. So you are actually correct.
Yeah. And I also think that just the general provisions that have been placed, and already to a large extent in very many areas of the Criminal Procedure Act, is the interest of justice generally does guide the operations of the court. So, even if this were to apply to cases that may have fallen before this court, before these acts, I don't think that there would be any problem, in terms of generally applying the principles that have found their way into the amendments. There's a question: a minimum sentence on the age of 16 years, was it affected? Was the age increased to 18 years? Karina, can you see that? Can you see that question?
Sorry, no, I can't.
It's actually come directly to me. Sorry, it says, it's the question, you did cover this, but maybe the person missed it. Minimum sentence on the age of under 16, was it affected? Was the age increased to 18 years? So this minimum sentencing of accused.
Yeah, the victim's age was increased.
Yeah, so maybe just
about the age of the accused, we're talking about the age of the victim.
I think maybe there is a slight confusion there. In terms of the person who's asked the question, the ages that have been increased are the ages of the victims. The minimum sentence applied to victims initially under the age of 16 and is now amended to the age of 18. I hope that does answer the question that was sent to me directly. So it doesn't affect minimum sentence as applied to accused people. Sorry, I heard someone saying something there?
Yes, Chair. The question is from Ezrom Setumo. I would like to check whether I can make her, him or her, a panelist so she can ask. Maybe they want to clarify this question.
That would be perfect. Yes, I think that's a good idea. Thanks very much, Matsidishi. Just let me know when that has been done, because I know that there is a slight little delay on the process by which to do that. Okay. If there are other questions in the meantime, if people could please put into the chat. Okay, here is another question. You should be able to see this one, Karina. Does this mean that there will always that there should be always cross checks between family section and criminal section when participants are different? So I'm assuming that means that we obviously have criminal processes operating around bail in terms of the criminal courts, yet we also have domestic violence processes through the family court. So it's this kind of hybrid going between, and how do we ensure information flows between? I think that's what the participant is asking.
I think it's actually a very, very, very good question. It's actually something I haven't considered. So thank you. Whoever thought about this? This is brilliant. Because if your criminal court are going to issue a protection order, your family court must know about it. So yeah, that synchronization needs to be there. Thank you. Praise to you. Yeah, I think really in this instance, we need to sit and synchronize basically now because of that requirement that the criminal court is required to issue that protection order. How are we going to register that with the family courts, or how are the family courts going to become aware that the criminal court had issued such an order? Otherwise, you get two court orders that contradict each other, or what? So brilliant question. Thank you so much. Never would have thought about that.
Yeah. Advocate Kambula, would you like to respond to that, or is it just something that we need to as a group actually just reconsider and look at how that information flows? I mean, I would assume that once the repository is up and running, that hopefully all of that information will flow between both the civil and criminal courts. But I'm presuming and hoping that would be the situation. Advocate Kambula, I don't know if you're in a position to answer that, or if we should move on to the next question.
Oh, thank you, Bronwyn. What I can say here is that, as the domestic violence is requiring the department to set up the integrated electronic repository for the protection, for the protection orders for domestic violence. So we have already developed that system, and now we are in a process of creating an integration of the system with the online application for protection orders, and also to link it with the criminal repository for cases of any kind of, if it's a criminal matter, then it goes to that repository. So then it will be able to extrapolate all these cases that will be flowing into the criminal repository and getting then into the integrated repository for the protection orders. So it's something that we thought about, and now moving moving forward with the project, that is phase 2 of the project, is to take then the online application, all right, solution, and the integrated repository for the protection orders to the IJS, a transversal hub, which is the integrated justice system transversal hub. That's where you get all the actors that are within the criminal justice system. They sharing the data electronically, and if you are the NPA, you are able to access the information from SAPS. If you are DOJ, you are able to access information. And now we have even included right now the Department of Home Affairs as well, all right, as part of the actors. Remember that they are not part of the criminal justice system per se, but then we thought that would be important of them to participate in that transversal hub. up. So this is going to be phase 2 of the process. But now, currently, the repository is in place and it has disaggregated data, collection of data in terms of disabilities, in terms of the age of the victims. Remember that the Act, it talks to child, it talks to older persons and so on. So we had to integrate those data metrics into the repository. And also we have taken also in terms of the races as well, all right, so that we know exactly as to which amongst the races, that are experiencing this situation but it's a number of data metrics that we did not have, previously, that we have incorporated into the repository. But we are calling it the integrated case management system, all right? But now we are deliberating in the department as to whether do we need to change the name and align it to what the Act is all about and so on, so that there is no confusion. Thank you so much.
Thank you very much for that. Yeah, very, very comprehensive explanation. And I think that probably also puts a lot of people's mind to rest, that we definitely have, or you definitely have, a very sophisticated process in place in terms of which to coordinate all that information. Because obviously one thing that most has been a big challenge the world over in all systems is the collation of evidence that we don't, or the collation of information that we have proper repositories in terms of that various departments can access. So thank you very, very much. Yes, Esrom, you wanted to ask a question in relation, I think, to the question that we discussed a little earlier. If you could go ahead, please.
Thank you. I wanted to ask, in terms of the minimum sentence, the minimum sentence for a person when the victim is under the age of 16 years is life imprisonment. I wanted to know if that the age has been increased to 18 years, or what is the position? Because currently, if you are under 16, the victim is under the 16, minimum sentence is life imprisonment, and then on the rape charge. And then when you are 17, is 10 years.
Karina, are we talking? Yeah.
It had been increased from 16 to 18. What did you mean by 10? I didn't hear the 10, about 10 years.
I'm saying the minimum sentence for a victim who's under the age of 16 is life imprisonment.
Yeah. Good.
But when the victim is 17 upwards or above 16 years, it will fall within part 3 of the minimum sentence, which is 10 years imprisonment. So I wanted to know if was the age increased from under 16 to under 18.
Not only was the age increased from 16 to 18, but that's indeed correct. In other words, a victim under the age of 18, a rape of a victim under the age of 18 falls in part 1. In other words, minimum life sentence. But a rape for a person 18 and above, of a person 18 and above that does not have a mental or does not fall in the category that I have mentioned, that now falls in part 2 with a minimum sentence of 15 years. It was deleted from part 3 and inserted in part 2. So that is very important to know that, because as I say, the length of the sentence is a very, very important factor to consider whether it's in the interest of justice to release the accused on bail. Thank you very much. Isran, I hope that has answered your question. Moving on to the next question. The written notices versus arrest. A written notice, you would only really find a written notice in the Child Justice Act. What you would find for an adult that would be, you would refer to that as a summons. What we would know in law enforcement, we would refer to JSET 175, which is different to a subpoena. A subpoena is for a witness, a summons is for accused. But for certain offences, a written notice or a summons cannot be issued because it's not the prerogative of the prosecutor or the police official to decide whether the accused can be released from custody. Only a court can. So certain offences can only be brought, an accused can only be brought before the court for certain offences if the accused was arrested. And that's why I started the presentation with State versus Yewu, because I see it very often, not only prosecutors, but police officials feel uncomfortable to arrest a person who was previously arrested but released because the case was withdrawn. Now, we all know very often, and specifically in a province like Gauteng, because our DNA reports takes very long, sometimes cases get withdrawn awaiting the DNA results. Now, under those circumstances, if the victim fell in the category that I referred to, that would make it a Schedule 5 or 6 offence, then the accused has to be arrested, even if it is a second arrest for the same offence, because we've got case law supporting that, and that is the only way that you can give effect to the legislation. And we are creatures of statute. We have to follow the statute as the legislature has set it out. If we are upset about legislation, then of course we take it to the court, to the Constitutional Court. But until that legislation is there, we have to implement it.
Thanks
Okay,
very much, Karina. There's a question underneath. I'll read it just in case people can't get access to the chat. It says, at what stage would a prosecutor draw a line to allege that the accused has a propensity to commit crime or crimes in opposing bail in line with Section 60 sub 4?
I'm not sure what you mean by draw a line. I mean, if I as a prosecutor is if I oppose bail, I would of course oppose bail in circumstances where I have the bona fide belief that the accused is a danger. In other words, I'm not going to oppose bail because I don't like that person's particular face, or I don't like the way that they wear their clothes or whatever. So there's no line for me to draw. If I have the factors that indicate the accuser's a danger to any particular person or to the person against whom the offence was committed, I have to submit evidence that he has the propensity to commit, or I have to submit the evidence at my disposal. And if that is specifically the offence, especially if the offence was committed against a person with whom the accused is in a domestic relationship, and the abuse had occurred previously, then of course it indicates the propensity. And that is information that I must submit. And that is why your previous question relating to how are we going to link the family courts and the criminal courts, also very important there in terms of to ascertain that propensity. For instance, if that person had approached because not all interim protection orders become final. So there might not be a final order because by the time that the final order was supposed to be made, the victim and the accused had already made up, and the victim didn't attend court, and the interim protection order was not made final. So it was not an order that the accused needed to mention to the court during the bail application, but it is still something that I, as a prosecutor, must be made aware of to indicate the propensity of the accused. In other words, all information to my disposal that indicates the propensity must be submitted to court. There's also been a case, if I'm not mistaken, at State versus or it's X, it was state versus X, or it was X versus the Commissioner of Police, or I'm not sure what the citation of the case was, but it was a case where a child was actually kidnapped and raped over days. And the parents and the accused was out on bail for an offense of rape. And the court, and he had a previous conviction for a sexual offense. And the prosecutor, during his bail application for that, the offense that he was on bail for when he raped a child, that was a 4-year-old child, a 5-year-old child, the prosecutor did not tell the court about his previous convictions, and that is why he got bail. And actually, the court found that the state, or that the compensation had to be paid to the family of this child, and it was actually family of the accused that he had kidnapped and raped. So this is extremely important. It's, as I say, it's not for me to decide what information I want to present to the court or not. If I have this, if I have the information at my disposal, I must present it to the court, and it's for the court then to decide whether it's in the interest of justice or not. It's not for the prosecutor. So we have. So that is extremely important to understand the mandate of each role player as in the whole process, and prosecutors must understand that we do not have the power to make that rulings. It has to be a court, and we do not have the power to decide what information is in the interest of justice to be submitted. It's for the court to decide that. So present all your information. And what is good about bail applications is hearsay evidence is admissible. In fact, you work only on hearsay evidence. You do not ask your witnesses in your main trial to testify in a bail application. So a bail application will be hearsay evidence. But what I also see in the chat box in relation to the retrospectivity of the procedural statutory law, and indeed we've got the DPP Western Cape versus Regional Magistrate Wynberg, fantastic case, 2002, sub 1, SACR 8, Western Cape. It's a fantastic decision. Whoever that state advocate, I forgot now who the state advocate was, but fantastic job. I wanted to personally congratulate her or him, because really it was, I think I'm in awe of that judgment. It's a fantastic judgment. So yes, these new regulations or specifications, requirements, or these new amendments will have retrospective application due to the fantastic argument by this state advocate in that case.
Great.
Yeah.
Thank you very much for that excellent, comprehensive. Sorry, someone is just asking the name of the judgment. It is in the chat, just above where we have. But again, if you just look at that, it's the DPP Western Cape versus Regional Magistrate Wynberg is the citation of the case. And if you just look at the person who's asking the question, Annette, I think is just, if you just look a little bit up in the chat, there is the full citation. There's another question, Karina, from that says, can you use a case that was withdrawn by the state, which was in contravention of a protection order against the accused, as evidence to oppose bail? So I assume that's, obviously
The propensity,
post it, yeah. So it'll be propensity. So go ahead, yeah. I don't want to answer your question for you. Go ahead.
Yeah, especially if that protection order was against another person other than the person against whom the offense was committed this time. I've done that many times. And because normally let me maybe explain it this way. In a trial, when you in a criminal trial, you cannot refer to offenses that the accused had committed against other people unless you have charged it. unless, of course, you try to establish similar facts. But I mean, it's not a similar fact. Yeah. Anyway, it's not. Yeah. Anyway, yeah. But yeah, because that is character evidence. But with a bail application, because one of the factors requires the state to prove the propensity, then of course it refers to character. Does the accused have the character for the propensity to commit these offences? So in that instance, you can submit evidence regarding offences that you had committed against other people or in other circumstances against the same victim, even if it refers to, in fact, if it refers to the character of the accused, it would be admissible in a bail application, but as I say, in a main trial, not. So very often when we say we're throwing the accused with the book, we don't just do it because we want him to be convicted on several minor offences as well, if we have a very serious offence like rape against him. But the reason why we do it is because then we can submit information in reference to prove that particular offence, even if it's just a traffic offence. I just want to create an impression with the court, and to create that impression, it's actually very good to charge him for very different, to show he has this propensity to ignore the court, to ignore law, to ignore law and order. Well, I don't know, I'm definitely going to suffer from Alzheimer's one day. But yeah, I forgot now. But yeah, but the fact is, and it is so. I mean, with a bail hearing, I would, even if the accused has the propensity to exceed the speed limit. I mean, it just shows he doesn't care about what restrictions you place on him. Simple things like that. And it really takes you a very far way to create an impression of a person. And normally, then, more often than not, a person that does behave in that way, he would exceed the speed limit at all occasions. He wouldn't abide by, say, renewing his driver's license on time. In other words, forever the accused ignores what the law requires from him. And that is really an important aspect to consider if you want to release the accused on bail subject to a protection order against the accused. Because what is the use of a protection order if the state already in the bail application proves he's going to ignore it? He never abide by any orders. And I must say, all cases where I have presented such information, and as I say, sometimes it's even minor offences that the accused, or what we in law would think, especially we that work in GBVs, would think of very, very minor offences, actually becomes extremely material if you look at the bigger picture and the accused's propensity to ignore court orders. And none of those cases had the accused ever been released on bail. I've always managed to oppose it effectively on the basis of proving that propensity.
I think that actually is an excellent illustration of the frustration sometimes on the part of many communities who are very disappointed when bail is granted in certain circumstances. And I think it's important to, obviously, like you say, strike that balance between, obviously, bail is not a given, that basically it must, in certain circumstances, be placed, all the information must be placed before the court. And either way, bail is not a right. You don't automatically have the right to bail. You have the right to apply for bail. And then obviously it depends on all the information that is placed before the court. And to a large extent, it is reliant on both your investigating officer and your prosecutor to accumulate as much information as possible to place before the court. And like you said, it's not in the discretion of the police or the prosecution to decide what's in the best interest or in the interest of justice to place before the court. All of that information must be placed before the court, and the court must make a decision. But obviously, we can't expect the courts to be making informed decisions without that information placed before them. So there is an incredibly high level of responsibility on police and prosecutors to bring all that information. And I guess that's going to be the proof in the pudding once all of these amendments, which are placing even more responsibilities on prosecutors and investigating officers to make sure that we have all that information. But of course, the beauty of, like you said earlier on, the beauty of bail applications, that it does, you can admit hearsay evidence. There's a lot more scope in terms of what can be placed before the court. And I think that that is a real recognition that very often that time frame when people are awaiting trial is a very dangerous period of time for victims. And if we can place as many, even if people are granted bail, that bail conditions are very, very strict and strong. And if there is a breach of those bail conditions, obviously that the bail can be withdrawn, which you covered extensively in your presentation. So I just see over here, there's a question in terms of the citation of the judgment. Can put that, it is actually up further in the judge. I just have to get it again. We can post it again. As long as that is the right citation. I can't definitely vouch for that's the correct citation, but I'm going to believe that it is, and I shall quickly place it into the chat and hope that I get it right. There we go. I've just placed that into the chat. Okay, so I hope that assists. If I'm just going to, yeah, like I said, I'm relying on the person who placed it into the chat that that's the correct citation. I can't vouch for it, but I'm assuming it is the correct citation. I don't see any other questions in the chat. Wanda, I don't know if there's anything else from the Q&A section. Sorry, I think these are all. Okay, here we go. Sorry, no, I think those have all been repeated in the chat group. Thank you. Thank you, Margaret, for placing that in the chat, that it's available on Safely. Okay, so people can see that as well. Right, are there any other questions that anyone would like to direct towards Karina on the presentation or broadly around bail, the link to sentencing, because there are all of these very big kind of links, technical, but very important to understand them. And also just to say, obviously, that the presentation will be emailed. Advocate Kambula, I'm not sure if there's anything that you would like to add at this stage, if there are no more questions from anyone. If there are any other issues that want to, I know it was a lot of information to absorb, but I think that's the point of this amendment, is that we all have to go and do lots of kind of getting our heads around it. Go ahead, Praise.
Okay, thanks. It's just two things that I would like to raise. One is as Pillar 3, I hope that you will recall this, that when we were considering the prevention strategy, the femicide prevention strategy, this issue was raised, that the risk assessment tool that we put together as a department and other stakeholders needs to be reviewed, because right now it will have to be at every service point, so as to ensure that the victims are, you do understand that if I do not report, then I might die, all right, and it might affect my children and so on. And I think that then with the prosecution having to consider the risk factors, this tool will also be assisting them when they are dealing with bail applications. So it's very, very, very important that we roll it out first, then we review it, because it was found that it needs to have the voice of the civil society organizations, because it was developed by Department of Justice and other stakeholders. So then we need to magnify that voice there, so that it is a tool that also the civil society organizations will be using it when the victims get to their service points. So that's the first thing, and it would be helpful for the NPA. Now, secondly, is to say that we also need to understand that for as long as Section 35 of the Constitution, or let me say this, the Constitution does not have a dedicated provision the Bill of Rights that speaks to the victim of crime, we will still be having situations where we have the accused persons being released by courts. Because the accused person, when the accused person comes to court, is armed with the Constitution. I know that that right is limited, but is armed with the Constitution. And the poor victim is holding the Criminal Procedure Act that must bow to everything that is encapsulated in the Bill of Rights. So who's got, there's an imbalance there already, all right? And it is a contravention of Section 9 of the Constitution that outlines the equality clause, all right? So, but then when they come to a court environment, there's a violation of Section 9, because one is holding the Constitution and the other one is holding the Criminal Procedure Act, which we keep on, amending and amending. So for us then to create that balance, we need to have the Constitution, the Bill of Rights, having a dedicated provision. It's either we amend Section 35 to also protect the rights of the victim of crime, because Section 35 is giving the suspected, the accused, the suspected, the arrested, and the accused person. So you can see that, the intention of the legislature was only for the accused persons. All right. So people, if you are accused, you are a person who has committed a crime. So if we are at this state in South Africa where we have a situation of overwhelming figures of crime perpetrated against women, and we have a constitution that does not have any provision that protects the right of the victim, we will have the endless amendments of Section 30, of Section 16. And even this one, all right, this provision, all these amendments that have been, enumerated here, we will have a situation, they are going to be tested by courts. The defense is going to come through with section 35 of the Constitution. All right. So we need, as women of South Africa, to speak with one voice against the Section 35 of the Constitution, to ask Parliament as to where is the voice of the victim of crime. Because Section 35 is about the protection of a person who has committed a crime. But what about a person against whom a crime has been perpetrated? Where is the voice of that person in the Constitution? Don't tell me about the right to privacy, the right to human dignity. We are sharing those rights with the accused person. But the accused person has one provision that is dedicated and focusing exclusively to the protection of the accused person. Where is the provision that protects the right of the victim of crime? So this is a discourse that I think that we need to engage with in the country. We will be able then to bridge this gap that we're experiencing between the accused person and the victim of crime when they come to a court environment. Thank you so much.
Thank you very much, Rose. I think that's a very, it's a massive area for debate, because I tend to agree with you in terms of your sentiments, and I know that the opposite side of the debate is, well, there are all these other provisions that do actually look after victims, but the fact of the matter is that we've constantly got to try and weave them into different pieces of legislation if they don't actually appear in an overt way in the Bill of Rights. So I think that that's a fascinating discussion to take forward. So thank you very much for that input, and I think that we all need to constantly apply our minds to that. Karina, there seems to be a question again in the chat box that says, is voluntary evidence from a person from the community in a bail application admissible? So I'll leave you to answer that.
Is what? Sorry, voluntary.
Yeah, so but I think the question that is being asked is if a community member has information that they would deem relevant or important through a bail application, is that evidence admissible?
Yeah.
Yeah.
If it's relevant. I mean, all evidence, only relevant evidence is admissible. So if it's relevant, it would be admissible.
And so maybe, I mean, I don't want to speak for the person who's asked the question. I guess on a practical level, very often community members, whether they're actually part of a community group or an organization or just support family or friends, may have information that they think is relevant. And practically the best way to go about that is to get hold of the investigating officer, give the investigating officer that information, and or if they have an opportunity to be at court, to have a consultation with the prosecutor before the bail application to give them, because then that person will be able to determine whether the information is relevant and put before the court. But I think the most important thing is that the more information that investigating officers and prosecutors have to place before the court, the better. So there's certainly nothing preventing community structures or members from approaching investigating officers and prosecutors to place that information before court if they deem that it would be of use to the court coming to a fair decision. So yeah, I think in a nutshell, it is possible to approach the people who will place that before the court, but they at the end of the day will make a decision whether it is relevant information or not. I hope that answers your question. Okay, is there anything, we do have a little bit of time left, but if I don't want to prolong it, obviously, if people, because it has been very intense, it's a very, very technical area of law, and it's very intense. But I can see from the email addresses that people have put in the chat, I think a lot of people here are from the criminal justice sector, which is very encouraging, from both justice and from legal aid. And obviously, we're all going to have to be very, very conversant in all of these amendments very quickly, because they're going to have quite a big effect on the way, particularly that bail applications are run. And also the whole issue in terms of changing from a police perspective, the use of so-called bail and these police and prosecutor bail, which is no longer going to be available in domestic violence situations, which obviously is a massive step forward to protecting victims. There's I don't know if it's a question, victims of crime, what is their repatriation? I'm not sure if you mean repatriation of their compensation. Then I'm going to, sorry, I don't know whether I can assume repatriation or if I should reinterpret that as compensation. Compensation. Is that okay? All right. I think maybe that is it. So, Karina, my understanding of the question is that, through criminal processes, are there any avenues in which victims of crime may be compensated? And then maybe just to touch on, which you're obviously aware of in terms of Section 300, but if we can have a look at that and then maybe look at civil options as well, maybe just to comment on that.
Now, you see, the only compensation really is through Section 300. And then, of course, Section 29 from the Trafficking in Persons Act 7 of 2013. But to prove damages, it's not so easy to prove damages. So you have to prove actual damages, and you have to prove a link between the offense and the damage. And that is normally where the problem comes in. Because a victim of crime is like anyone else, really. I mean, your life has evolved and many things have impacted positively and negatively on you. So it's sometimes very difficult for the state to say that a victim that, say, had gone through a very acrimonious divorce, and that was where her relationship before the divorce was plagued with domestic violence, and then 6 months after this very acrimonious divorce, she got raped by a work colleague. So it's very difficult then to assign quantity or quantum of damages to this particular act, considering that so much else had also happened to that victim. And I think the victim in the State versus Zuma case is maybe not a bad example, because that was a person that had been subjected to sexual violence from a very, very young age. So can you really say if someone had experienced their first sexual violence at age 12, that the damage that she would present with at age 30 from one incident, can you really then say that that damage is related to that one incident? Or did that one incident not maybe just contribute to the negative outcome? So that is what we've experienced in trafficking, how difficult it is actually. Also, in terms of trafficking, very often our victims were doing sex work prior to being trafficked into a brothel. They were addicted to substances. So it's very difficult then to say after the victim had been released from trafficking, where she was exploited for, say, a period of 2 years. So it's very difficult to say that the damages or the addiction or the HIV is related to that 2 years where she was exploited. But that said, however, once a criminal trial had been finalized with a conviction, then it is the easiest thing in life to actually then sue the accused for damages, for a civil claim for damages. Because what really makes a court case very expensive, and I have to be honest, I don't think I would be able to, with my income, to actually go full on for a civil case where I have to present evidence with that amounts to court days. For any civil case, probably if you are going to present evidence in that case, then of course your costs mount, because advocates charge per day. So, but if you already have a criminal conviction against that person, then then all the civil case is going to do is 2 hours just to ascertain the quantum of damages. So then you decrease your cost tremendously to take the accused through the civil procedure. And then damages can, and I mean, it's not unknown. Many of these domestic violence cases had ended up in civil trials where the victim had sued the perpetrator for damages and successfully sued the victim for damages. And another thing, with the amendment to the prescription period for criminal offences in terms of Section 18 of the Criminal Procedure Act, the Frankel case, remember that also the Constitutional Court in that instance removed also the prescription that is applicable to civil cases if it was a sexual offence that was committed against the person. So the person not only can institute criminal proceedings against the accused 40 years after the offence committed, the victim can also institute civil proceedings against the accused many years after the offence was committed.
Yeah, and maybe just to add in terms of the civil aspects, I mean, as Karina has correctly pointed out, very unfortunately, civil litigation is very expensive, and that prohibits most people or excludes most people from pursuing civil claims. And then the obvious other aspect is that very often perpetrators or accused or suspects themselves are not particularly well resourced in order to potentially pay a damages claim if there were to be a finding against him. So something that is interesting and worth mentioning is the Victim Support Services Bill, which was put out by the Department of Social Development, and apparently is in the process, hopefully, of going to be, basically taking into consideration the comments that were made and then introduced into Parliament, hopefully in the next year or so. Makes a provision specifically for the provision of legal aid for victims of gender-based violence to pursue civil claims. So that is a really big step of progress, because really, as Karina says, civil litigation is extremely expensive. And if victims choose not to have gone through the criminal process or have been unsuccessful in the criminal process, don't have a criminal conviction to rely on when they sue civilly. So one has to take that into consideration as well. So I think that's a really nice development if that provision makes its way through into law. And then, of course, legal aid is going to have to be provided with appropriate budget in terms of which to support victims pursuing civil damages against perpetrators. There is another question, says, does indemnity after issuing a warrant of arrest of an accused who is out on bail justify the opposing of bail being reinstated? In other words, can it be used as evidence to oppose bail being reinstated? Karina, can you see that? Can you see that question? I'm not completely sure I understand it.
What normally happens is if an accused does not appear at court on the date that he was ordered to, a warrant of arrest would be issued. Then the case would be postponed for 2 weeks for the forfeiture of the bail. Now, what happens then in that 2 weeks, the accused comes to court, but that warrant has already gone to the police. So what we then do is we give him an indemnity to say he had appeared on this day. So that indemnity he keeps with him. So when the police knocks on his door to say, come, I'm going to take you to court now, he says, no, I've already appeared. This is my indemnity. The case was postponed to this and this date. That would, of course, only counts, I would say, if that is my interpretation correctly, if that is indeed what you've meant, then that would definitely depend on why the accused did not attend to court on the date that he was ordered to do so. If that was just generally because the accused doesn't abide by court orders and just know that if it's, and that has happened, I mean, I've done cases where that would happen. The accused would willfully misunderstand the date. So the accused would come the day after the case was before the court, just to frustrate the victim, really. Very often that would be the reason, to frustrate the victim. So the victim would be make all the arrangements to appear to testify on the 16th. The accused forgot or misunderstood the date, and he thought it was the 17th. The accused is there, but victim not. So under those circumstances, especially if it happens more than once, that would definitely be a factor that I would mention to the court, would argue that is frustrating the exercise of the administration of justice. Then he should not be released on bail. And I'm certainly not the only one. I know many colleagues, we would definitely, especially if that, as I say, if it happens more than once. And if there are absolutely no reason. And what I have done a case where the accused also constantly would misunderstand the date, and the court actually cancelled his bail because the court said, I cannot rely on you to hear correctly. So let me rather send you to prison. Mr. Boyan said, oh, I loved him. Let me rather send you to prison, and then the prison will hear correctly, and they will bring you when you need it. And that was lovely. We could finish the case.
Yeah, it just shows you that basically if you do have police and prosecutors who are prepared to fight for those situations and are very aware of all the facts of their case and they know the details, that they are very quick to be able to expose accuseds various ways of prolonging and postponing and frustrating efforts. And as we know, so many victims, because the court processes can drag on for these very reasons, eventually withdraw, and that's obviously the objective of the accused. So we've always got to keep that in mind around that. I see there's a question here. Obviously, we were talking about compensation. That's obviously referring back to the compensation issue about the establishment of a victim compensation scheme. Maybe just and Advocate Kambula may be in a better position at this stage to answer that question. But the South African Law Reform Commission did do a very extensive investigation on victim compensation schemes a number of years ago. I was privileged enough to be part of that committee that looked quite extensively at that. And unfortunately, the bottom line is that it was deemed unaffordable in South Africa. And then there was a proposal that it was restricted to victims, particularly of gender-based violence. And that just doesn't seem to have really grown feet and run in the right direction. And I'm not sure exactly at what stage of that process is anymore. I don't know whether it's been completely canned or whether there is still talk and possibilities of a victim compensation scheme. I think in theory, yes, it would be great, because then we wouldn't be dependent on perpetrators or suspects or defendants having resources to pay compensation. But I think the theory and the practice may not be as we would like. I don't know, Praise, if there's anything that you'd like to add to that, or if we should just leave it at that. I know that we're running out of time now as well. We need to wrap up quite soon.
Thanks, Bronwyn. What I can say is that it is not just one issue. That is still a nebulous area, to discuss. And most so now that we have experienced a decline in the economy and so on. But now the NSP, I would like just to draw to the attention of everyone who is here. The NSP has shifted that responsibility to the Department of Women to ensure that a fund has been established. And unfortunately, that responsibility, it is within the indicators of Pillar 3. And if we know that in our annual plan for this financial year, we have put in that indicator for the Department of Women to begin to start, to think about how to go about, providing that fund and where is it going to be coming from and so on. I think that's what I can say right now. Thank you.
Great, thanks very much. That's very helpful. So to the person who asked the question, I don't think there is anyone who works in this area that would be opposed in principle to having a compensation scheme, but the reality is resources and available resources. Are there any other questions that people would like to pop into the chat? Okay, I think that we're nearing the end. Give everyone a little bit of a breather before the next round of webinars. Karina, would you like to just give some closing comments, and then I will close up I'll give you just a minute or two, and whatever your closing statements are, and then obviously over to Advocate Kambula if she would like to add something, and then I'll close. Thanks, Karina.
Thank you very much. Thank you very much, Bronwyn, and thank you very much, colleagues, and thank you for fantastic questions, and especially the one about retrospectivity, which is definitely something I'm going to add to the presentation, something I should have had in the presentation in the first place. So thanks for alerting me to that. And yeah, good luck, colleagues. I hope we all do our best. Our victims do deserve that.
Thank you so much, Karina. Praise, would you like to say just a last couple of words for the participants?
Just to thank them for attending, and also to say that we need this information. So we need to invite more, as Bronwyn has said, that drop your email address on the chat box so that you get the direct invitations to the webinars, because the webinars will be running until the first phase. It gets up to the 29th of July, but now we have started then to include others for August as well. So thank you so much.
Thank you very much, Praise. And yes, thank you again for inviting me to moderate this very, very interesting session. It was fascinating. I really enjoyed it. So on behalf of Pillar 3 from the NSP, who have hosted and organized this, thank you very much to the incredibly skillful people who organize these things from I never know what to say, electronic, digital perspective. So thank you very much to Mochidisi and to Luando and to Bafana for supporting us so ably and running it so smoothly. And yet again, just to re-emphasize that Pillar 3 has a lot of responsibilities around this piece of legislation, and that we're all in this together to implement together. Thank you very much again to Advocate Kambula for her leadership and insight into this whole process. I know that she's been working day and night to get all of this through, and we will all continue to work on these acts and the amendments of the acts. And I think we'll probably continue to have a lot of webinars and updating of information and continual education for both civil society and all of the state actors. So I think that leaves the end of today's webinar. Thank you very much, everyone, for joining us. It's Friday. I know there's still half a day to go, but wishing everyone a very peaceful and safe weekend, and we hope to see you at the next webinars. Thank you very much for joining us. Goodbye.
Sorry, Bronwyn, would you please inform them of the other webinars that we have today on your phone? Yes, thank you.
Wait a minute. Now, I've got so many on my. Let me just see quickly. Wanda, maybe you're the better person to quickly just tell people, if you're here, what the next webinars are. I'm sorry, I've got so many on my.
Oh, okay, thank you so much, ma'am. What we have at 12, we have the overview of changes of clerk for the courts, which starts at 12 up until 1400 hours. And also we have one at 2 o'clock, which speaks to 3 GBV Amendment Act, psychosocial services in GBVF matters. And also there's other one also at 12 that goes concurrently with the one, overview of clerks, which speaks to older persons. Sorry,
Luanda, I think there are some people that are asking in the chat where they would find the links. I know that you've sent them out to the various groups, so I'm not sure with people who are not getting the links, what is the best way for people now to access those meetings? What would you suggest?
okay, because I won't have time to actually write all the emails right now. I can just write my email address here so that they can just drop their emails. Then I can just forward the links to those that don't have them. Yes.
Okay. Please, Luando is going to put his email address into the chat now. And if people can then just email him directly and he will send you the link. And at is it to reply to your question around the links on Twitter? No, they are not necessarily always on Twitter. Sometimes they are, sometimes they aren't. But these links really go through to people who are on the emailing list. So if you were to please email Luando now, he will add you to the distribution lists and he sends out the information with all of the links and all of the webinars. He's doing an extraordinary job in terms of getting all of this information out to people. You can see the attendance in these webinars are always way more than 100 people. It's just incredible to see that. Carol, I can't really see the name of your, if you could just email Luando, if you could see there his email address in the chat, LDIKWENI is the first part of his email address at justice.gov.za. If you could just email him and he will add you and send you the links to the webinars, not only for today, but the future webinars as well. All right. Have I missed anything else? Are we happy to wrap up? Okay. Thank you very much again, everyone. Keep well, take care, and we'll all see each other soon in the next webinars.
Thank
Bye-bye.
you.
Thank you.
Thank you. Bye-bye.